In consideration of the charges, we probably need to cover a couple of things. During the course of the prosecution's closing argument, he attempted to minimize the police interview of January the 25th, 2007. And I think the rationale behind that approach would be this. The jury heard the tape. It lasted some 4 hours. During the course of the police interrogation of Mr. Taylor, the police repeatedly said, "I know you may have gone into the room. I know you didn't really mean to do anything because you didn't do anything to the girl in the room." He was not completely gender correct because he consistently referred to as gal, but I'm not going to say that here today. But he would say, when you went into the room, you found her in a condition. And when you found her in that condition, you didn't know what to do. You didn't know what to do when you found her in that condition. Think about how many times during the course of that interview, the detective, if it wasn't Detective Rochelle, it was Hillebrook, and then the other officers come in. And Mr. Longsworth has to tell you that, well, you know, that's just a tactic that they use. They don't really believe that. I mean, that's just something they say. Because they didn't really have all the facts at the time. They didn't know about the fibers. They only knew about the DNA on their legs. They only knew about the DNA in the bed. But had they known about the fibers, they wouldn't have told Mr. Taylor that we know that you didn't commit a murder. We know that you found her in a condition. Then he went on to say, are you ashamed of what happened after you found her in this condition? Is there something you're embarrassed about, something you need to tell us? They said it repeatedly, over and over. Did you do something that you need to tell us about? Are you ashamed? I submit to you, he was ashamed. And let me tell you why he was ashamed. If in fact, a person who's not supposed to be in a dormitory, who's already excluded from Buell Hall, finds himself in Hill Hall, where he's certainly not supposed to be. He finds himself in a room where he's certainly not supposed to be. He finds himself in a room with a person who is deceased. He finds himself now, and I'll come back to that point, subsequently in the police station, and he's being asked questions about it. And the prosecution says, well, you know, he lied to the police because he didn't give them all of the information. And I submit to you, and I say use logic, common sense, and judgment. He did not tell the police a complete version of what happened. Ultimately, he gave them a statement. He didn't tell them a complete version. And I submit to you, because he was in the room and he masturbated on a deceased person. Is it somewhat, you may call it despicable, you may call it perverse, but it doesn't make it murder. Perverse? Yes, it is. Murder? No, it's not. During the course of the jury instruction, you listen closely, and you'll hear instruction that says, you cannot commit a criminal sexual conduct on a dead body. You can't do it and be in violation of the law in terms of commission of a felony. It doesn't work that way. It may be a despicable act. It may be one that you're embarrassed about. It may be, in street vernacular, somewhat freaky. And that it is. But does it make you guilty of murder? No. It makes you guilty of perversion. Now, during the course of the closing argument of Mr. Longsworth, we talked about Dr. Casson, and I'll cover him in much detail. But I just want to mention the fact that it was stated that Dr. Casson performed 14,000 autopsies. And so we know his testimony should be credible. That I agree with. But does that make him infallible? And what I'm talking about is this. Do you remember my questioning of the doctor when I asked him specifically, did you perform a test post-mortem to determine whether or not this young lady died of a cardiac arrhythmia? Answer was no. Then I went back again and said, well, doctor, let me tell me, is there such a test? Answer is yes. Out of maybe the 14,000 autopsies, maybe he performed them in the past, but he didn't perform it this time. And you may say, well, what's the importance of not performing it this time? Let's just talk about this. You got a person charged with murder. We're talking about murder. Dr. Casson basically tells you, by the process of elimination, I came up with asphyxiation. And how do you do that by the process of elimination? Well, you remember the questioning in the area of how do you get down and narrow it down? He said, as to the manner of death, you have to choose from disease, which is natural causes, which, by the way, would be cardiac arrhythmia. Injury, which could be suicide, which you can eliminate, homicide, or accident. You remember that category. We went through a lot of detail on it. He said, I eliminated suicide because it's very apparent that she didn't kill herself. That's his testimony. I eliminated accident because he could find no obvious reason that we can say that death was a result of an accident. So he then found himself limited with the one option, he said, which was homicide. Wrong. He didn't do a good job this time. And he's a good pathologist, but he didn't do a good job this time. He had another option. The other option was natural causes by cardiac arrhythmia, but he failed to perform the test. Then he comes in here and didn't perform the test and basically said, now I'm over here on this arena by myself and this is all I'm stuck with. And I ask you to convict a person based upon that. There's no evidence whatsoever that he put, when Dr. Casson testified, to demonstrate that she didn't die of a cardiac arrhythmia. Nothing. That's why I asked him the medical questions. There's nothing to demonstrate that. He said the process of elimination. But he didn't eliminate cardiac arrhythmia because he failed to perform the test.